Guys for taking time out of your busy day to be here. I'm really looking forward to seeing what Brandon has to say about today's topic. So he's an excellent speaker. Just to introduce Brandon a little bit, Brandon founded Legacy and Life Law Firm, LLC, after a decade of experience of helping clients plan for some of the most important parts of their lives. From helping young families as they grow, to protecting young or vulnerable children, to transitioning to empty nest phase of life, through managing dreaded diagnosis, and finally passing on values and wealth to the next generation. Brandon graduated from law school with honors from NIU College of Law. Before going to law school, Brandon taught AP history and coached high school soccer after receiving his master's degree from the University of Southern California and a bachelor's degree from the University of Minnesota. So without further ado, help me welcome Brandon.
All right.
There you go.
Thank you.
Take it over.
All right. How you guys doing? All right. So first thing I'd like to mention is with a small group like this, questions just on the fly, just spit them out as they come up. So I'm happy to be here and looking forward to just getting some information. When it comes to estate planning for business owners, the big thing, the kind of spoiler alert or cut to the chase, is estate planning for business owners is just as important for everybody as it is for everybody else, only more so. As you'll see, we're going to run through some hypos. And things get complicated and messy a lot quicker than otherwise for people who are W-2 employees, for example. So that's what we're going to go over. You can see I have Columbo here. There's at the end I have just one more thing. You can always tell how old of a reference you're making when the picture can't even get a high quality resolution of it. So that's I guess maybe if you want to know who Columbo is and you don't, we can talk afterwards. Maybe that's one of the questions you can ask. So just kind of going forward here. See if I got this working again. It might have fallen asleep already. There we go. So about me, you heard my bio. You can see my family there. I have 2 kids, 5-year-old now and a 2-year-old. That was New Year's last year, my wife, Gianna. And it's a bit of my resume. The most important thing I think from my background that kind of differentiates me a bit is the teaching background, taking intangible ideas and kind of breaking it into bite-sized chunks. But my Midwestern reserve, frankly, makes me embarrassed to even kind of put up this kind of slide. That's why I had to soften it with the family. But the point is, as far as some of my background, so you know who's talking to you, I'm also, this year I was appointed and accepted on the Illinois State Bar Association's Committee for Public Education because of my teaching background. So I'm involved with that. We do a lot of mock trial and outreach to like schools, high schools, junior highs, just lawyer visits a classroom for a day, that type of thing. But what I do, why I do it, is you can see there on the slide. I like to look forward. I don't like to argue about the past as a lawyer. It's not all rosy situations that I'm always dealing with, but at least we can make things a little better for clients. Then we have here some pictures, some more context. This is what's most important to me. I'm a big soccer fan. That's a picture from the 2010 World Cup. I went down to South Africa with my brother and one of my best friends. And that's the goal where the U.S. scored at last minute against Algeria to advance out of the group rounds. I was at that game. You can see my family. One of the things that I've experienced is a bit of loss also. After these photos were taken, this is me being married in 2014. My dad passed away just after this photo a few months later. My mom in 2020, and then this year, of all things, my brother passed away. So I don't bring that up to bring that down in the group, but some of the things I'm talking about, like my brother and I had some investment real estate together as business owners. I've been through this personally, experientially, not just as an attorney who's read a book and thinks it's a pretty neat way to make a living. And then the kids, of course, are there, and that's why I'm doing what I do. They're also the reason why getting a meeting with me between 5 p.m. and 7 p.m. is almost impossible. I prioritize that kind of golden hours with them. So on to the estate plan. There's 3 kinds of estate plans, and I like to start with this on almost anything I do. Because of that first column, the nothing. Sometimes we lose sight of choosing to do nothing is still making a choice. And so you should know that doing nothing puts you on the state's default rules. That's the track you're on. It's called intestate succession. But what happens is hard. It depends on what your situation at death. Do you have a spouse? Do you have kids? Do you have stepkids? Are your parents alive? All those things. It's basically a big if-then kind of analysis. But when you pass, you're going to have probate and probably the most involved version, meaning the people you care about are going to have to buy like an insurance policy through the county so that they know you're not going to run away with all the money. They're going to have accountings to provide judges, all that sort of things. That's before creditors or ne'er-do-wells get involved. So that's not good. Then you have your will, which I view the estate planning documents kind of as tools, tools in your tool belt. Today I have roofers at my house, right? They're putting a new roof on. They're using hammers, nails, ladders, all those things. That's the job to get it done. But if they were going to redo some landscaping, those hammers would be a lot less useful, right? They'd need different tools. So that's what we're talking about here. What job are you trying to get done really dictates what tools you need in your estate planning toolbox. So will, the great thing it does is overrides the state's default rules. So you're not dependent on what the state of Illinois or whatever state your residence in telling you, here's what happens when you're gone. It's also very good for nominating guardians and executors. So for young families, for example, even frankly business owners, they can probably get away with a will if all they want to do is make sure the kids get to the right spot after a date night gone wrong. Wills, powers of attorney. I'll unpack all that. But it does not avoid probate, which is the biggest misconception about a will. All it does is override the rules. So if you're thinking it avoids probate, you're going to be kind of like using the hammer to plant a tree. Like maybe you can get the job done, but it's going to be a lot of work and not too fun. Then trusts. Trusts are the way to avoid probate. And your family gets to control the timeline after you're gone of when things come out. You get to dictate that in the trust. Example I always use, again, for my personal life. My mom passed away, it's coming up, the anniversary, it was November 29th, 2020. And her birthday was February 1st. So my brother and I, as we were kind of working through everything, the grief, the practical side of getting the house listed and sold and cleaned out, we decided it'd be really nice if we could distribute on our birthday, for our kind of process. So we had a hustle, we were able to do it. We got it done. But we could have decided to rent out the property and keep it. We could have done that. We could have waited 3 years and then sold if the market was bad. But it was up to us. We didn't have to wait for a judge or anybody else. So the trust really puts that in your family and your loved ones' control. According to the rules, you're going to write them. So it's another thing, it's private. Court processes are public. So if you're out of court, you're in private territory. There's a reason. One of my favorite musical artists last year passed away, Jimmy Buffett. You haven't really heard anything about his estate. It's all in trusts, all in corporations, all layered up. So there's no public court filing that any reporter can get their hands on. Obviously, most reporters aren't off after you and I, but family members can certainly look up in whatever county public filings, and sometimes that's an issue, right? Come up. So that's the three kinds of estate plan. You can do nothing. You can choose to kind of be on the will train tracks, or you can choose to be on the trust. So I'm going to run through a hypothetical. This is a client, hypothetical. We have a married couple, Nancy and John, and they have 3 kids, and you can see what they have. I just kind of made up stuff, right? But I think this is pretty fair illustration, right? You have some good amount in retirement and the house. That's typically where people save the most, except for business owners. They put a lot of money in their business. So I gave John an ownership interest in an LLC, and then they have their checking, savings, CDs, and their Roth, and so on and so forth. So this is what they have. So the question becomes, what if they did nothing and John passed away? Now you can see here, a lot of this is okay. The IRA's retirement money, that's probably going to have beneficiaries on it. Nancy's going to be the beneficiary. The house, she's probably on the house as a joint person, so I made that assumption. And that's not going to need any. CDs, the checking savings, the Roth, again, beneficiaries. But the thing that mucks this plan up is that LLC interest. Now, LLCs have what are called operating agreements. If you have an S-Corp or other corporation, it's probably articles of organization, is what they're called. They're essentially the same thing, just different names for different kinds of businesses. So in this case, you have an operating agreement that could say, hey, if any member passes away, here's what happens to their membership interest. That's very, very rare. I can tell you, I can probably count on one hand in 10 years, 10 plus years, how many times that's happened. Moreover, I'm inserting that, or I'm making a trust to insert that language if the operating agreement doesn't allow it. So what's probably going to happen is it's going to be probate, and you can see Nancy and the kids are going to be now business partners with whatever. And under the rules of intestacy, Illinois' default rules, Nancy gets half of that ownership interest, and the kids get half. So now, let's say John had one business partner. It was just 50-50, between each other. Now that business partner would have a quarter partner in Nancy, and the kids would split the other 50%, which would be 16 and 2/3 each. So that'd be 8 and some math on the third that I can't do on the fly. But now all of them have to agree on a sale to themselves or any business arrangements. What happens a lot is maybe one of the children is actually running the business with their dad. But now the other two say, well, I have a percentage interest, a 16% interest in this, and I think it's worth this if you want to buy me out. So now we have a deal where the siblings, not only there's the money side of, is there enough money to physically buy the person out, but think about what that's going to do to the relationship. You know, you have a sibling, all of them are grieving the loss of their dad, and one is trying to, maybe they feel squeeze a little hard and threaten the business or the memory of dad. It can be really, really corrosive to those relationships. So that's what happens if you do nothing in this case. They're going to have to all negotiate. You're going to have at least 4 or more people have to agree, which is tough. I mean, we have so many people in the room today. You know, we could talk about sports and probably not agree on, you know, if firing the offensive coordinator was the right move for the Bears or if they should have hired him anyway. We're going to have different opinion, let alone when big money's on the table, right? It's hard to get people to agree. So now with intestacy, the big questions are here. How do you protect vulnerable beneficiaries? What if one of the kids is in the middle of a divorce? That money's going to him and all of a sudden he's going to be subject to that divorce. Or that business interest now is going to be subject to divorce. What if they just can't handle money? What if they have creditor issues, credit card debt? It's just going to them. It's just automatic. Certainly if they have special needs or a disability from a car accident. The way I categorize it, you can see here, just problems that make money worse. And frankly, not always problems. Sometimes strengths are turned kind of toxic when money gets involved. So how do we protect those people? You can't with intestacy. Again, you're relying on the circumstances at death. If one kid passes away before you, what happens? Are there grandkids? Are there not? Surviving spouse of that child of yours, your in-law, are you going to take care of them? It's all up in the air. It depends. Blended family issues. I have a client right now. We're about a year into it. It's over a year. 13 months into it. Her husband passed away, and he had a business just in his name, and he had one kid from the previous marriage. They had a child together. He has one. So she has to ask him, that child, that grown man child, for his 0.25% interest in that business for her to be able to keep running it. Now, fortunately, in that case, she was running the business, so she had the knowledge and the wherewithal and all that stuff. She didn't have to catch up there. But now, all of a sudden, her relationship with her stepson, which she thought was really close, they were just the kids this whole time, now has not been for the past year. Now it's who's in his ear, you know, trying to milk as much money as they can out of this thing. So it doesn't take too much for this to go wrong when you don't do anything. So now we'll go through a hypo with what if they made wills? They relied on wills. So now John passed away, and you're going to see it's the same. All those things are the same, except for now instead of intestacy, we just have regular old probate, which we can probably assume John named Nancy as the beneficiary if she survives, and that's a very safe assumption. So it's the one we're going to make here. And so Nancy is now partners with whatever other business partners. So you've eliminated a lot of riffraff and complication just by making a will, but it's still not as clean as you might like. But in probate, what happens is, you know, all these questions come up. Does Nancy want to be part of the business? Does she know? Is she aware? Is she going to accept a buyout? How is that buyout going to be valued? Is there money in the business for the buyout? I have another client, very wealthy people, maybe the wealthiest people I've ever worked with. They did trucking as their business, but that's a very capital, you know, not liquid capital heavy. So if they had to split money, if somebody had to cut a check to Nancy in this hypo, they'd have to sell properties or trucks or something to get that capital going. And that would destroy the business or weaken the business. So a big point is there money in the business to secure that buyout for Nancy? Or is the owner left trying to negotiate, hey, can we set you up with a payment plan and all these things? You know, how much can we afford? How much do you need? All those things where emotions just get really involved and it can become very difficult to resolve. Does Nancy change her will after John passes away? I always say there's two kinds of people in the world. There's pool boys and there's casserole ladies. And motivations I've learned don't change. That's something that happens in life all the way through to the memory care in the nursing home. You'll see love triangles and all these things. So does Nancy meet some pool boy, and all of a sudden he's getting 50% of her stuff, and the kids are lessened? Maybe they disagreed on how to handle one of the kids and the inheritances. Now maybe Nancy changes it for the better. Maybe John was a little stubborn. Want to use gender stereotypes? I don't know. But maybe John had it right, and Nancy just wants to give him money when it is dangerous to give him money. She can change that after he's gone. Does the will allow for flexibility for vulnerable beneficiaries again? Again, people who just have things that money makes worse, we want to be able to protect them. And then the worst part of probate is you have the time, expense, and public nature. So time-wise, at a minimum, probate's about a year long from beginning to end. The expense, ARP will tell you that the expense is anywhere between 4 and 7% of the value of an estate is probate. I think that's way too wide of a range, but they're taking a national look at it. It really depends on if there's young kids and things like that. But at the minimum, you're looking at probably $5,000-$6,000 in Kane, DuPage. Cook will be a little more, but in this area, that's probably the cost you're looking at for probate. And then again, it's all public filings. So most people that come to me want to avoid probate, especially after they've gone through it themselves. Like, Marks of the world would say, hey, we just went through this with my dad and his business. I got it now after all this struggle. How can I make sure my kids never have to worry about this? That's something I hear all the time. So then what happens if they made a trust? So you can see we have the same assets, same everything here, but you can see next to the LLC now is owned by the trust. So I'll back up there. We'll expand on it a little bit, but all we do in the estate planning is we just create some paperwork that takes the membership interest or the shares, depending what kind of business it is, and assigns it to the trust. That's all we do. John still has control of it. He hasn't given up anything. But now that it's in the trust, we're going to have a trust administration run by a trustee that John would have chosen while he's alive. Maybe Nancy, maybe not. Depends on the circumstances. And I'll break those down here in a bit. But we're out of the court. We're out of public review. We have rules that are literally in black and white for what happens for this specific membership interest when I pass away. Here's who gets it. Mark has been running this business since he was 16 years old with me. He can take it, but he's going to have to cut his sister and his mom $2,000 a month for 10 years. We can do whatever it is. We can make up those rules and agree on them. So trust administration, private. You can customize it. You can customize it for each kid. Mark has to pay off his sister. She's doing great, but his younger brother, he has some struggles. So we want to make sure maybe we'll put it into a trust for him so that when he needs it, he can get it, but he's not sitting in his checking account, just waiting to be blown. You can do all that. You can make things more tax efficient. And the biggest thing that's missed when you think of, even when somebody has their corporate interest, their business in their trust like they should, is the thing called a distribution trustee. This is a tool that's been around for a long time, but is way underutilized, I think. It's a specific trustee that you authorize to handle a specific piece of your trust. Nancy might be the overall trustee. She can handle the house and the checking accounts. But maybe there's a friend 2 towns over that John's met through a Chamber of Commerce. And he knows, hey, this guy knows the business, knows all this. He can value it and get a fair sale. I'm going to make him the distribution trustee just for the sale of the business and getting money to my wife after I'm gone. You can carve that out. That makes a big deal, a big difference in, we're talking about administering this thing after John's gone. So this is kind of a nice stopping point too, because I just described a bunch of problems, and I don't know about your life. I have very short fuse for people who only bring me problems and don't bring me solutions along with those problems. So questions we can answer now if you have them, or we can get into answering these 2 questions of how to get these solutions in place. Anything I've said that I've muddled or haven't explained clearly enough for you yet? Okay. All right. Well, thanks. Well, I hope there's questions coming up. So what are solutions? Let's start there. So a few things you have to consider. First, I spent this whole hypo talking about death, so I want to put a slide in here. It's worth pausing on incapacity for a few minutes. Incapacity, frankly, is the thing that really gums things up. There's a lot of default rules that the law's had for 100 years on what happens when somebody dies. So at the very least, you have some rules. But incapacity is really catching up. Issues of dementia, things like Parkinson's, all those chronic illnesses, human beings have really only been living long enough for the past 25 years, essentially, to really see those things be big issues. That's why you see memory care facilities popping up, all the time now, because we're finally aging, where we have, instead of having 6 months or 2 years of having to deal with that illness. We have 5, 10 years, maybe longer, of dealing with that. So incapacity, the most important thing I think is a power of attorney, specifically in this context, a property power of attorney. I always call the property power of attorney a financial power of attorney, just to get over the misconception that it's just for real estate. So this is a financial power of attorney where you can give specific authorization for your agent, somebody you name. Maybe John names Nancy. Maybe it's that business friend. Who knows? To handle business operations, to draft and sign buy-sell agreements, to deal with corporate resolutions or reorganization ideas, to be able to sign tax returns. I mean, simple stuff, but important. That can be actually sign additional trusts if that's what's needed after somebody's incapacitated. The right kind of power of attorney can do all that, but it needs to be beyond a little bit the default. The default Google Illinois power of attorney, what you get won't have that. You need to add some things to it. The trust agreement is another key document that you have. This is, again, like I've harped on a little bit now, you get the trustee that you've named that continue operation when you're incapacitated. So now the business isn't struggling because you're not able to sign off maybe on payroll or whatever it might be. It could be as urgent as that. It could be as something as lines of credit that your business needs to succeed to get some cash flow. Your trustee would be able to sign those, even if you're just in the hospital for a week. Think about the end of year times that we're getting to and how things kind of creep up and all of a sudden need action right away. Not the most complex or earth-shattering things. But if you were in a car accident and incapacitated for the wrong week of December, you could miss filing deadlines on some really important stuff, right? So the trustee and your agent under the power of attorney can handle all that for you. Then you have the operating agreement. So we have 3 documents: power of attorney, trust agreement, operating agreement. Operating agreement is the rule book for the trust. I'm sorry, for the company. The rule book for the company. So this says, hey, John and Brandon have gone into business doing whatever. Here's the agreement. Here's what happens if Brandon's incapacitated. Here's what we're going to do. Maybe we force a kick out where we say we're going to take the last, year of revenue, maybe 3 years averaged out over a year. We're going to put a little multiplier on it for our industry, and we're going to get Nancy or Gianna, my wife, that money, whatever it is. That could be as simple as that, but at least it's in there. Maybe it's like, oh, we'll just keep chugging along, and we'll call the power of attorney if we need something signed. We authorize that. So you have, again, simple mechanisms to keep going, to keep business going if you're incapacitated. Then we get to documents planning for death. So again, you can see the same kind of documents: trust agreement, operating agreement. I've gone over those in the hypo. But I want to touch on the buy-sell agreement here and the funding of the buy-sell agreement. Now, you can see the words life insurance on the bottom of the slide there. Everybody has their own opinion. I don't sell life insurance. I'm not here to sell you life insurance, but it's the best way, I think, to fund a buy-sell agreement. So that's what it's there for. You could also self-fund it. But I'll back up for a second. The buy-sell agreement. This is a playbook specifically for the transfer of a business interest to a business partner or a third party. So if you have an agreement with a competitor down the road that, hey, if I die, do you want to buy the business? Sure, we'll do it reciprocally. Great. We can do that, and we can have the terms. Here's how we're going to value it. Maybe a kind of business in downtown Naperville is different than is in Lisle, a bakery, I don't know, whatever it might be. You can have different multipliers specific to your business, how to value it, how to go through the process, deadlines. Do we need a 25% lump sum payment due within 60 days? Or what do we want to do? All those things. You hash those out while the sun is shining, while everybody's in a good mood. So you're not doing it through lawyers and judges after the fact. And then you have to fund the thing. So on death, a great thing to receive is a life insurance for the business. If they get the money to buy out the Nancys of the world after John's gone, let's say, now the business has the cash. They don't have to stress about, do we have to lay people off or sell some of our holdings or negotiate with Nancy over like a 10-year payment option? No, we have a life insurance thing. She gets it. She's done. She's not in the business anymore. She's got her financial security from her husband's work in this business. All that's taken care of. That's the easiest way to fund it. The biggest missing piece from this planning on death is that somebody's missing, maybe they have 1 or 2 of these documents, but they don't have all 4. You need the trust to keep things off the probate radar, so your ownership is held by the trust. You need an operating agreement to provide for not only incapacity, but all the process and boundaries for sale upon death. Who's allowed to be a buyer, who's not. Then if you have a specific business partner or buyer, you get into a buy-sell agreement so that you can have the specific boundaries for that person. Frankly, we don't have to be naive. We probably have different values for how we might let go to a family friend for a little less than we would for a competitor down the road. So you can enter different buy-sell agreements with different people. And then the thing needs to be funded. Because otherwise you might have to sell everything the business is valued for in order just to get the family out of the business. Questions on that? That's a whole lot on that slide. Anything coming up? Seeing stares, seeing anything?
Just a question.
Yeah.
And I'm familiar with trusts and
Yeah.
the process of looking at them. And I have a partnership, or it's an LLC,
Yeah.
of a service business, franchise
Right.
training business with my son. He has a larger portion than I do. And we have an operating agreement in his name and in my name.
Mm-hmm.
So when, obviously, look at my wife and I had trust on, other
Yeah.
assets and whatnot. So I would have to change on that operating agreement. I would have to change my name to the trust name, basically.
Yeah, so when we have clients, who have LLCs, we just do a simple, it's called assignment of interest, so your membership interest. We don't have to change the operating agreement at all. It's just something you sign along with the trust when you sign the
So I
trust.
don't have to on the operating agreement.
Right.
I can still leave
But
it
then
in
when you
my-
get to your annual report and things like that, that's when you have to update. Yeah, we have different owners technically because now we got the trust instead of you. So all that stuff would naturally come out of it. And that's enough paperwork to get it off that probate radar. Yep. So that's what you do. It's probably 3 pieces of paper total, but it saves a huge mess when you do that. Because if you didn't, the value of your business would count towards your probate estate, and you'd be just like, going through it. It would eventually get to your trust. You'd have to go through probate first. So that's where you want to not miss out. Okay. So those are kind of the solutions, those documents. So how can we get them in place? I want to kind of walk through a little bit, maybe behind the curtain on what we do when we're working with clients to get this done. So again, in a hypothetical, lots of times I'm writing this handwriting on a whiteboard. I break down their documents and then their assets. So we're going to stick with the kind of hypothetical we did earlier with these assets. I want to go through these documents and get each one of them in place. So there we go. This is what a plan looks like. So we have on the left side all the documents and assets. We put a trust in place. And inside the trust would go things like a house. You want to get the real estate in the trust to avoid probate. You want to certainly get like CDs, little things like that are kind of, generating interest and might have a good amount of value. Just get those in the trust. It's just easy to do. And then you get the LLC or the S-Corp shares assigned to the trust as well. Those are all housed within the trust. There's a whole lot of things that are outside the trust as well. Your IRAs, your life insurance, but those should all have beneficiaries on them. That's all I consider part of trust planning, but technically it's not owned by the trust. And it's one of the more common questions I get is, are we putting the IRA in the trust? No, you can't without paying all the income taxes due on it or breaking the Roth treatment, which you want to keep. So we just make sure we have beneficiaries on them. Now, if you have loved ones who fall in that kind of vulnerable category for whatever reason, we can make the trust the beneficiary. That works. We don't actually change the owner. We just update the beneficiary. So that's what it looks like. When we get to planning these things out, you can see I put check marks here. We've covered almost everything except for the checking and savings accounts. Those kind of stay outside the trust as well. It's a real practical question. These days, banks are making you close your account, open a new one, get new account numbers, new checkbooks, redo all your direct deposits, direct debits, all that kind of stuff. So it's a hassle and a headache, and we can do other things rather than put it in the trust that make it easier to use. So again, I try not to sign my clients up for problems or issues down the road. So I want to go over trust here a little bit, just the 3 key roles of a trust. There's a grantor, which I call the trust maker, but the more common term by far is grantor. The reason I call it trust maker is because the role is the person who makes the trust, who decides on what rules it is. So I find it, back to kind of my teaching background, is a less confusing or abstract term, right? So that's the person who decides the rules. Those are my clients, right? People telling me, hey, my son needs this amount of structure, or I want to lock up this trust because I think my wife is going to find some pool boy that I don't want to have the business interest go to. Fine, we can put all those rules in there. Then there's a trustee. That's just the manager of the trust. Most of my clients are their own manager. A big misconception when it comes to trust planning is like, do we pay annual fees or anything else? Do we pay a bank, pay the attorney to be trustee? For most people, the answer is no. You're your own trustee. You've managed the CDs in the house and even the business just fine. We don't need to insert anybody else in this. While you're alive and healthy, you can be the manager. We will name successor trustees to take over. So we will name people to say, hey, if I'm incapacitated, for example, here's who's going to take over managing this trust. Or certainly when I'm gone, here's who's going to manage the trust. Then there's the beneficiaries, which, of course, who gets what when you're gone, but also the beneficiary while you're alive is an important question for trust planning. You're also the beneficiary. Your client, my clients, are their own beneficiaries. So even if they're incapacitated and their trusted cousin is now trustee of the trust, their duty is still to the beneficiary, which is them. So they can't distribute to the kids yet. They can't do anything until that person is gone. They're still the beneficiary. So being your own rule writer, your own rule follower, and the beneficiary of the rule, you can do whatever you want with these trusts. They're easy to use. They're not complicated, or they should be easy to use, I should say. That's how the trust works. Those are the three key roles. Every trust, irrevocable trust, the most complicated trust, the Rockefeller's family's trust, they all have these roles. It's just a matter of what switches we're toggling on and off within them, where the attorney comes in to make it do the work you want to do. You know, it's kind of like back to the hardware analogy, right? We're all in Home Depot looking at the tools. What aisle are we walking down? Which even kind of hammer are we picking out? That's all where the advice and getting the right tool for the right job comes in. So if we have somebody that's incapacitated, this is what kicks into action with this plan. You have your financial power of attorney. So the agent can make decisions for your non-trust assets. Let's say like this example here where we have an incapacity, a car accident, and there's some brain injury, right? And we find out, oh no, we didn't get the LLC assigned to the trust. What do we do now? Are we just up a creek? With the right power of attorney, no, you're not. Your agent can sign that assignment paperwork for you and get it into the trust. You have inside your trust, remember you have the house, the LLC, the CDs. So if we're thinking of John and Nancy here, Nancy can still decide whether she's going to stay in the house or if she needs to sell it or maybe get a different one with a first floor master because John has some mobility issues after the car accident, whatever it is, she can do all that. She's still managing this trust. Maybe John's named a special person to manage the LLC within the trust, a special distribution trustee. Or maybe they've got the operating agreement that says, hey, we understand John's incapacitated. Since it doesn't look like he's likely to return to the business, here's the kick-out options that we've already agreed on. And we can start funding that and getting Nancy the money and then letting the business partner continue on with the business. That's what kicks into action when you have that emergency. And again, I mentioned incapacity is the big thing that really grinds people to the bone. If you read like government reports, they'll phrase it, the leading cause of bankruptcy is unreimbursed medical expenses. What that boils down to is essentially stuff that Medicare doesn't cover. And what that boils down to is issues with mobility and thinking. The long-term care chronic illness is what eats away at businesses, at personal finances. So to have things when you're incapacitated, you can have some agility. You have trusted people that can do things for you. It's huge, huge. So then on death, what happens? So I put, it's really thin. I should have thickened that thing up. There's a red line there. That's flat line for a reason. You're gone. And what happens is your will now, because you have a will even when you have a trust, your will takes the things that were just in your name and gets them into the trust. All right, so your checking and savings accounts, they'll get into the trust for your surviving spouse or your kids or whatever it might be to still be able to use the money without having to go through probate. Then the trust has beneficiary language on it. Again, maybe it's the spouse, maybe it's the kids, maybe it's whomever. They'll go there. And then the beneficiaries on the retirement accounts and life insurance, that could be pointed anywhere. Again, we can make the trust the beneficiary, or we can make it the kids or whoever. We can make the business partner the life insurance beneficiary so they get their buyout, whatever it might be. But that's what happens when you die. All these things kick into action. And the key here, I've mentioned a couple times, avoiding probate, is we want to have the will handle less than $100,000 and no pieces of real estate. If you do those two things, you don't go through probate. It's that clear. It's a bright line test. It's a cumulative $100,000. So you can see why checking and savings accounts Most people aren't carrying that kind of money in their checking and savings accounts. The other thing that's not in the slide that I probably should have put on it, the car. I used to make a joke about, like Bugattis or something. These days, you buy a nice SUV, you're darn close to the $100,000 mark. So I've gotten, in the past 3 years, I've had to be more and more careful with my clients' cars and making sure I know what kind of car they're driving. But they're a depreciating asset anyway, so as long as they're not buying a car every year, you'll probably be fine. But either way, we want to stay under the $100,000 mark to avoid probate. And then you can have the trust distribute things, easy peasy, on your own timeline. If you're like my brother and I, we can distribute on a birthday. If you're like Nancy, who might be needing money quickly to replace income from her husband and running that business, she can get that life insurance policy in. That usually you'll get a death certificate within like 10 days of somebody passing. If you fill out the claim form, that's usually another 2 weeks. So we're talking about less than a month that you can have that life insurance check in the checking account. So it can be real quick. All right, so I want to focus on the trust here for a little bit and break down what's in. It's kind of the last phase of stuff here. So if we think about the trust, you have the house and the CDs, and then you have the LLC, which is kind of treat that two separately. So the house and the CDs, you probably have maybe Nancy being the successor trustee of that, and she's probably the beneficiary. If she happens to not be alive, maybe you have one of the kids be the trustee and all three of the kids be the beneficiaries. That can happen on its own timeline, independently of each other. Often, CDs pretty default have a maturity upon death. You don't have to wait for the new maturity date. So you distribute CDs right after death. In the house, you sell it or deed it to a family member. But then you have the LLC. Maybe you have an attorney, a CPA, a business colleague, a friend. They can be the trustee of that, but the beneficiary will still be the surviving spouse or the kids, so that they still get the payout. So it's important. I just wanted to point that out. You have one trust, but it can be using its left and its right hand here. It's ambidextrous, right? It doesn't just have one thing that needs to happen here. You have to wait on it, wait on it, wait on it. Okay, that's done. Now these are parallel tracks. Especially depending on the economy, selling a business can be really tough, right? Finding a buyer is tough, probably even in a good economy, find the right person for the business. So we can get that done. Then within the LLC itself, this is the furthest layer we go. I want you to understand what it looks like. So you have John's interest in this LLC, and then you have the life insurance policy that pays out the death benefit. So the death benefit is going to go to that Nancy or the kids, whatever it might be, and the interest is going to go to his business partners according to buy-sell agreement. So boom, nice and easy. You sign the one paperwork. Once that life insurance check comes in, boom, notarize it, supply it to the successor business owners, and then they're off and running. The next time they do their annual report, they just say, hey, I'm now the sole owner because John's passed away, and here's the paperwork if there's ever an audit or some state official or IRS official needs to know any of the details. Meanwhile, Nancy or the kids got the value of what their dad worked for probably a significant part of his life. They've gotten that money. They've gotten it in a tax-advantaged way, and they're moving on with their life, remembering their dad for what the values he passed on to them. And then, a lot of this focuses on the money side of things, but all this being easier, it saves money. There's no doubt about it. But it also saves the memory and the legacy that way, which I think is really undervalued, especially in the long term. So, putting it all together here. First lesson, you can choose one of the three plans, and choosing nothing is still a choice. You do need a buy-sell agreement and the funding for that agreement. And if you do that right, you can keep your life partner from being a business partner or the kids from running a business that one or all of them don't know anything about. So that's the value of getting this done. And the likelihood you get it done right increases as you move away from nothing, move away from a will, and then get into a trust plan that's done comprehensively and correctly. So, one more thing, that's why Columbo's on here. Oops, I pressed it one too many times. One more thing, not related to really anything I just said. By the end of the year, the federal government requires all business owners to register with FinCEN. If you haven't done that yet, this QR code will allow me to get all the information we need to register that for you. We charge a small fee, $75 to do it for people we know. But if you can also call your CPA and your attorney, they can get it done. I want to let you know, when I did it for my own business, it took me about 10 minutes to get done. So if you're getting billed for more than 10 minutes of somebody's time, I would raise a red flag. That's what I have to say about it. But if you want us to get it done, we could do that. Otherwise, we can take questions and answers. That QR code will just take you to like the intake survey if you want to contact me, and we can answer specific questions that way, but I can do general questions now. Yes, sir.
My wife and I, we took a life insurance policy. First kid we had now, they're getting older. So my youngest daughter, I think in 2 years will be in college, so we're going to renew it.
Yeah.
But, I didn't have a business 30 years ago, whenever, or I should say 20 years ago. I guess my question is in a couple of years, I always just get the insurance policy where you pay, you don't pay into it, you pay what you have to. So when you're done, there's no money in there. But, you spoke with the Rockefellers. I mean, back in the day, they would take out, a huge one. And then when they died, they would get the money back. I forgot how they did it. But the point being is there's a lot of different life insurance policies out there. And my kids will be somewhat self-esteemed out of college. So I don't know if you have recommendations. You didn't say you really do life insurance policies, but it's more of a
I do have a favorite kind of life insurance policy, but let me frame it this way. I like permanent solutions to permanent problems. So when we're talking about a buyout of a business interest, I stay away from like a term insurance policy that you can outlive, and all of a sudden it's not around to be there for the buyout. Then the two alternatives to that are universal life and whole life. Universal life's come a long way in the last 10 years since I started. It's gotten a lot better, but whole life is way more boring. And I see that as a plus, not a minus. It's just a simple, old-fashioned, it's the policy the Rockefellers used, and you can just chop off a few zeros on it and use it for yourself. It's really reliable and predictable. It allows me as an attorney to say, okay, we've taken care of this problem on a permanent solution. When you look at death benefit to premium, you'll have to pay more premium to get the same death benefit on a whole life, but it's because it's guaranteed to pay out, so they have to. Whereas universal life, there are situations where it won't pay out, and they can lower that.
But universal health, is that the same as whole life? Like if you die, you get paid out, but there is a difference?
There is a difference, because a lot of times they're sold, and this is where my cynical brain takes over now. First thing you should know, commissions are about twice as high on universal life than whole life. So there's a reason for that. Second of all, they're often sold on, hey, yeah, if you can't pay it or you run out, it'll just kind of pay itself. That eats away at the value, and if the value gets to zero, the policy goes away. So again, we're in a situation, if you live too long, you don't get it. Whereas in whole life, the longer you live, the better it gets. But I'm not here to say that, the difference in expense isn't, worthwhile. It's something to consider. And there are better ones now that have more guarantees in them. And life insurance companies, when they use the word guarantee, they have to take it very seriously. So the guarantees in them, the whole life you can stand on and rely on. So I like that as the attorney in the room. But as the budget setting thing, the right universal life could probably get it done. It's just, there's so many out there. I guess they're like attorneys. There's enough bad ones out there that, the good ones kind of get lost in the mud sometimes. So you got to be real careful picking which one you want. Yeah. Any other questions? Anything else? Yeah.
Children are usually covered by the will of their parents. What would be your recommendation for when say a child creates their own will, right?
Yeah. There's two events. One, when they go to college, they should have powers of attorney. I do that all the time for kids and clients when they go to college, but that's necessarily the will. The will probably, is more important, at marriage, kids, those types of things. It's probably the right point for that. Just again, to override the state's default rules, because if there's, in our example here we ran through, we assumed John's parents were gone, but if not, then you got a spouse and parents splitting things, depending on the situation. You want to avoid that. You want to avoid that mess. So the will would override that. But it's probably marriage. It's probably the first point. But the other thing on the powers of attorney for kids in college, there's plenty of situations where a kid has a medical emergency at college, and obviously they're not minors anymore. So the parents don't have any rights to ask a hospital what's going on. And also the medical records. Most universities have a form for educational records. Most universities have a form for their educational records that they should fill out as well and have a parent have access to, so they can follow up with professors and see what exams are and all that stuff depending on what's going on. So, yeah. Other questions? All right. Well, that's everything. That's the whole show, folks.
I got one more question.
Oh, yeah.
So on LLC versus S-Corps, I'm actually an S-Corp, which took forever because I kept like losing the paperwork. One time they said it got wet, but
Yeah.
anyways, after 3 years, I'm an S-Corp.
Okay.
But my question is, there are advantages to that where you get a salary that can keep the money back in the business.
Yeah.
You know, I'm still kind of at the point where I'm getting the salary and not putting it back in, but
Right.
do you see other advantages as a single S-Corp
Yeah.
versus a single LLC?
Yes, I do. I'll give you the best example I can give. My law firm is an LLC, taxes, and S-Corp. So that's where I put my own money, my own advice, right? So,
But are you an S-Corp then, or?
it's treated like it for tax. So I have to do payroll and all that stuff. Yeah, that's the salary thing.
But it is, that's why I was confused, because it's like, oh, you're an
No,
LLC.
no, it's an LLC, but for the IRS and Department of Revenue, it's an S-Corp.
Okay, that's my question.
Yeah. So usually when people like reference it like you just did, the assumption I made in my head is you're probably an LLC tax and S-Corp. That's where that switch happened, which is fine. And the nice thing about it though, that to start the answer, is any mistake you make is a one-year mistake only. You can always correct it. You always go back to pass-through taxation or go back to S-Corp taxation. You just make the mistake for 1 year, which isn't ideal, but not the end of the world. But I think if you have a business that's, making revenue beyond the loss leader stage of its life, right? Then it doesn't take much income, more than really, if you want to get more than a couple $1,000s out of it a month to make the S-Corp make sense. That's kind of the
You're
threshold.
saying just throw that back in the S-Corp and it just kind of keeps
Right, because
staying
then
there
you,
bigger
yeah.
than using it for
Right,
business.
yeah, because then you can actually hold it without having to pay tax every year on it, like you do with the pass-through entity like an LLC, where all the tax just comes to you every year no matter what, right? Yeah, so you can avoid that. So I think, again, if you're able to take home, and I've talked to a lot of CPAs who are always interested in their opinion, we all arrive at about the $2,000 a month. If you're taking that home, that's when the S-Corp starts to make just financial sense to do that, at least the treatment from LLC.
I would say taking home is that minus your salary, so that's the plus.
No, that's the salary. If you're looking at whether it's a draw from an LLC or the salary from an S-Corp, if you're looking at about more than 2,000 a month, then that's about the right point to really go. That's when it's like, yeah, it's time for change. Before then, you can waffle a little bit, 6 in one hand, half dozen in the other, but at that point, it makes sense.
Yeah, and then it just, whatever you take as salary or whatever, that counts as, regular income through your husband and wife.
Yeah. And I will say, from an attorney standpoint, I've seen this, a lot of attorneys have very strong opinions about it, much stronger than I just told you. And again, my cynical brain takes over. It's just what they're used to doing. So they'll say, oh, no, you need an LLC. Oh, no, you need an S-Corp. I think it's more detailed and nuanced than that. It really depends. But so I would resist anybody saying you have to do it. Because again, it could be right in 1 year with an income and tax situation and politics with tax laws, all that, and it could be wrong the next year.
Yeah, I read
Just gotta
a
go back
Warren
and
Buffett
forth.
book, and he said he did that even before he started his business, or when he started his business, in the 60s. I thought that was kind of funny.
Yeah.
So I'm like, oh, if he's going to do it, maybe I
Yeah,
can do it right
he's
away.
doing
But,
it,
I
that makes
did.
sense, but you gotta think about where his income is and make sure that's not the qualifier, as opposed to our mere mortals like us. All right.
Well, we could just give a round of applause. Friendly reminder for next month, our next month's speaker, Erin Doble-Wingstrom with the Doble Group of Raymond James, is a financial advisor. So we will be here next month to close out the year with financial advice for you and your business. Really quick, also wanted to give a shout out